talk about this right now with former federal prosecutor Doug Burns. He joins me. Doug, good to see you. So my first question about this, I guess, is, why did the judge rule on the matter first? Why did not, a jury get this and then they decide, they render a verdict? Because this is a civil suit. The judge ruled today, yeah, fraud was committed by the former president.
No, it's a great question, and it's a two-word answer: summary judgment. In a lawsuit, one party or the other can petition for what we call summary judgment, and the test, without getting in the weeds and in simple English, is, is it clear from the papers that there's no issue of fact to be decided, and therefore the judge can render a verdict. This is partial summary judgment. Obviously, I didn't study the file that closely, but it's partial because they are going forward, according to many media reports that I looked at, going forward with, other parts of the case in terms of whether he did or didn't, commit certain legal violations. So it's a partial summary judgment ruling. And then, of course, the other point to be made is that the question of damages is a separate question. And I'll address that in a minute. When you ask me a couple more questions.
Yeah, no, Doug, I just want to go over from the New York Attorney General's office. They put out some of the big takeaways. One was the judge, Judge Engoron, canceled all of the defendants' business certificates in New York. So I thought that was interesting also because, that was part of these lawsuits on whether or not the Trump organization and the former president, can operate their business going forward in New York as well. And so we're also hearing from the former president, Doug. I don't know if you can see this or the viewers can see it. This is the statement. You can see how long it is there. Former President Trump really going on a diatribe after Tish James and the judge there. I just want to read part of it. I'm not going to read all of it. This is his response. He says, the widespread radical attack against me, my family, and my supporters has now devolved to new un-American depths at the hands of a deranged New York State judge doing the bidding of a completely biased and corrupt prosecutor, in quotes, Letitia James, who ran for office based on a Get Trump platform before even knowing anything about me. So you can imagine former President Trump not happy with this ruling today. I mean, what happens now? What can or cannot the Trump organization, Donald Trump, do in New York when it comes to business?
Well, there are lots of legal steps still remaining.
All right.
You don't need me to tell you that. I'm surprised that the judge would have issued that draconian move of canceling certificates. That's the type of thing that would normally be addressed in the later portion of the case, the so-called damages or relief phase. So that's very surprising. It will be appealed. But let me say this. I mean, the former president is correct. That this individual ran on a platform of getting him. I've said in other contexts with other prosecutors that should really not be allowed or sanctioned in any kind of political campaigns. Once again, the tedious editorial. I'm not defending Donald Trump. That's not the point. When I look at a case, it doesn't matter whether it's Mother Teresa or Charles Manson. Completely irrelevant. And in this case, I'm going to tell you 2 points that are very interesting and very important. Point number one, there was really no loss to the lenders. And when I was in the United States Attorney's Office for 9 years, agents brought cases all the time. Doug, the guy lied. He said he made $300,000 last year. Well, guess what? He made $110,000. The first question we ask every single time is, what's the status of the loan? It's performed 100%, Doug. We would decline the case. Now, here's the key to what's going on. They are correct, hyper technically, that the submission of the document with the inflated number is the legal offense. And that's what gives them the wiggle room to do this.
I see.
But they're not fooling anybody, myself included, that under prosecutorial discretion, when the loans perform, you don't do it. Again, it sounds like I'm defending Donald Trump. It has nothing to do with that. No matter who the person was, if the loan performed, we would not accept the case for prosecution. Next point, very important, and that is that these are not, Cape Cod houses in the middle of the sticks. These are notable signature buildings in New York City.
Right.
So these lenders do all kinds of due diligence and appraisal work on their own. So in the end, I mean, look, I call it the way I see it. I tell it like it is. And the bottom line is a highly, highly, highly political move. And what this man is guilty of, there's no doubt about it. He's guilty of being a braggart, a self-promoter. Yes, he did inflate a lot of things. He said his apartment in Trump Tower was 30,000 square feet. It's 10. He said it was worth X millions of dollars. It was worth a third of what he was saying. But again, those aren't necessarily legally actionable. But I think your audience, your viewers will find it interesting. You can make moral judgments about that all day long.
Oh, sure.
You can make ethical judgments about it, of course. But the point is, you know, if the loan's performed, and these are signature buildings where the banks would do all kinds of their own appraisals, it's really, it's kind of a troubling case legally to me.
Doug, will there be any, you know, fines, penalties, other than, you know, limitations on doing business in New York? Will that be a part of this, do you think, or will,
yes.
you know, a separate kind of jury and judge have to decide damages or not?
No, spot on. But you're raising two different things. This is a civil case, and it's important to note that. So in the civil case, you know, the trier of fact will determine the amount of damages and so on and so forth. But there may be civil fines as well. In criminal cases, you know, every federal criminal offense carries a fine and so on. So there could be. But this case will be very important on appeal, obviously. You know, there's a lot of negativity about Donald Trump in violation of my rule, which is don't even look at who the person is, just crunch the legal X's and O's on it. So it's a troubling case in my view.
Okay, so Doug, while we have you as well, I want to talk about Hunter Biden, and I want to talk about Rudy Giuliani as well. That seems to be yet another major legal story a lot of people are talking about. So this is what we know, that Hunter Biden sued Giuliani today and another attorney who used to be Giuliani's attorney, saying that the two wrongly accessed and shared his personal data after obtaining it from the owner of that Delaware computer repair shop, the Hunter Biden laptop in the news again. So the suit accuses Giuliani and attorney Robert Costello of spending years, quote, hacking into, tampering with, manipulating, copying, disseminating, and generally obsessing over, that's the language in the suit, the data that was taken or stolen from Biden's devices or storage, leading to the quote-unquote total annihilation of Biden's digital privacy. So, Doug, you and I, last week, we talked about the Hunter Biden suit against the IRS over similar violations of Hunter Biden's privacy, alleged violations. And now you have this case as well. And I would be remiss, you know, we got to note the coincidental kind of timing of both of them. What did you make of this today? Is Hunter Biden really going on the offense here?
Well, yeah, I mean, it's counteroffensive, counterpunching, and so forth. You know, get out to the public that, you know, as bad as you may think this laptop is, and the salacious photographs and so on, you know, showing drug use and cavorting with prostitutes, the reality is they violated my rights. I have good news for him and bad news for him, and the bad news outweighs the good for the plaintiff, Hunter Biden. The good news is that under federal law, and I know the viewers like to do a little research, which is easy, 18 USC 1030. I've worked with that statute many, many, many times over the years. That's a computer fraud statute, which makes it, quite simply, a crime to illegally access without authorization, you know, computer data and information. The problem for them, though, which I'm sure you've heard, is that when the laptop was dropped off with John Paul Mac Isaac at his shop, an agreement was signed. And that agreement specifically said, Andrew, that if nobody claimed the laptop within a period of time, I believe it was 30 days off the top of my head, then it becomes the property of John Paul Mac Isaac, excuse me. So the point is, if nobody picked it up in the 30 days, and if that clause is held enforceable, you know, it could be some type of open legal question. The point is, if, again, John Paul Mac Isaac then owned the property, he was free to turn it over to anybody he wanted. And then by extension, they were free to do whatever they wanted on it. But again, I don't prejudge the lawsuit. It may be a little more complicated than that. But I do think that the language in that agreement is going to be difficult for the plaintiffs.
Okay, also Robert Costello, one of the defendants in this, who used to represent Giuliani, who in a separate case is suing Giuliani over unpaid legal fees here. So we'll just have to kind of see how this all plays out here. You know, Giuliani quite embattled himself, former New York City mayor, former attorney, senior advisor to Donald Trump when president. And I haven't seen anything if he's responded to this lawsuit. But I just want to go back to the point about Hunter Biden going on kind of the counteroffensive in the wake of his indictment there. Is that at play here, or is this just all happening at once, do you think?
No, again, you know, we live in a 24/7 sort of media cycle, obviously. Yeah. You know, impressions can be created that can get baked in a sense. So I just think it's sort of a counteroffensive move. You know, I'm sure he has good lawyers. So this point about the agreement, I'm sure they have an argument in waiting to address that. They're almost undoubtedly going to claim that it's not enforceable. They may also claim that Hunter Biden, I don't believe he was the one who personally dropped it off, but I could be wrong. So, you know, they'll delve into that type of thing. But more importantly than the outcome of the case is the point you're highlighting, which is sometimes it's just good to have people walking around saying, oh, all that stuff about the laptop. Well, wait a minute, he's suing the IRS and Rudy Giuliani. So, I mean, you know, maybe, you know, people aren't legal experts and so on. And I'm not saying that, you know, pompously or patronizingly, but the point is, you know, the average person like, oh my God, Hunter's now suing. Oh, good for him, et cetera, et cetera. And that's more public relations, obviously, than law.
Sure. Doug, also just one last story we want to get with you as well. We haven't talked to you about all of the, you know, drama and the legal saga surrounding Senator Bob Menendez, the Democrat from New Jersey. I just wanted to get your thoughts on the indictment itself. Our Capitol Hill producers caught up with him on Capitol Hill today. And one of the questions they had is, why won't you resign? To which he responded, because I'm innocent. So, like I said, we heard from Menendez on camera yesterday. He remained quite defiant, going so much to say possibly he might run for re-election. He has stepped back, though, from chairman of the Senate Foreign Relations Committee. But he is remaining defiant. He's going to be in court tomorrow, I believe, for an arraignment. What will you be looking for then?
Well, it's interesting because, you know, everybody's saying, you know, he is innocent. He is. He's absolutely innocent right now as we speak. He's presumed innocent. Nobody's proven anything against him. But the reason I'm smiling is, where was all of that when it's in reverse with a political figure from the other side, which is troubling. So you'd like to see uniformity in those concepts. Now, having said that, I read the indictment, and it's very, very strong, obviously. It's going to be adjudicated on two sides of the aisle. Side one is, what did he receive? The gold bars, the cash, the Mercedes automobile, and who did he receive it from specifically, and why did he receive it, et cetera. You know, I'm being sarcastic from the conference room. You know, did his rich aunt die, who was eccentric and have all this stuff, and it was delivered to him? Of course not, but you get my point. So where did all this come from, et cetera? They claim that on some of the cash envelopes, you have the fingerprints of the person who paid him. That's going to be hard to defend, okay? You know, criminal law is the mother of invention. Oh, I invited the guy over and I showed him my aunt's cash and he touched it, being sarcastic. But that's one part of the case. The other part of the case, 10 times more importantly, is what official actions did he take, if any, in return for all these lavish gifts? Jurors presume, look, nobody's just going to give you all that out of the goodness of their heart. They want something in return, but the law requires that he take official acts in return. Yeah. So we'll see. There was a well-known case involving the former governor of Virginia, McDonnell, where the Supreme Court of the United States trimmed back what is considered official acts, and they specifically held that McDonnell just setting up some meetings or even attending a little event with the company that gave him some gifts wasn't enough. And that kind of emboldened Menendez and led to him sort of escaping like Houdini from the prior case. But let me say one thing last.
And the McDonnell conviction was vacated after a while, so there is possibly that Supreme Court ruling might work in Menendez's favor. To your point, I think that's what you're getting at. Yeah.
No question, because he's going to turn around and say, I did normal things for constituents, but I had a chance to look at it closely. And they're saying that he tried to interfere in some prosecutions. he accessed sensitive documents and made them available to the Egyptian government.
Right.
Again, I don't prejudge it. If they can prove all that, it's going to be strong. But I do want to point out that for him to say that he took this money out of the bank for emergencies and because of his Cuban heritage, I think that was a mistake, because that's going to be so easy to disprove if it's false. Okay?
Oh, okay.
Serial numbers on the bills, bank records from his banks, etc. Maybe it is true. Okay? I have no idea yet, but I seriously doubt it, because nobody keeps $500,000 for an emergency. You keep 5,000. Okay?
Doug Burns, I think we'll leave it at that. That was good to leave it at that. As always, we do appreciate your insight. I know we kind of went long today, but there were so many legal topics to get into. We appreciate your time.
My pleasure. Thank you.